Right, we're just letting everyone settle down here in Sydney. And I'm presuming that with all the technology that's surrounding us here, that those who are on the webinar can hear us clearly. No doubt someone will leap out up the back and throw something at me if I'm not talking into the microphone. So as you're aware, our purpose today is to continue a process which has been going on now, for about 3 years, since the process of revising the Code of Conduct, or the Code of Professional Conduct as it is currently called, commenced. And so we're now at the stage where the Code of Conduct has been approved by Council. It is now available on the website, and hopefully all of you have had a chance to engage with it at some level, and hopefully during that discussion process. So what we wanted to do today was just to move the discussion along a little bit further, not necessarily a lot further, but to ask everyone to start thinking about what sort of guidance it is you would like to have, in the sense that we now have a code guidance group, which both Stuart and I are members of, and that group is obviously working away hard on some things which we'll discuss with you later in the session. But I guess the main thing that we would like to get back is, well, what is it that would be helpful to you in each of your roles? Because obviously some of you work in life companies, general insurance companies and so on. Others are consultants. Others work in wider fields. And of course, some of us are working in areas which would be considered highly non-traditional actuarial fields. And yet, if we're members of the Institute, then the code applies to us in whatever circumstance we find ourselves. So I think it's important that we continue to create and maintain a dialogue to ensure that things remain relevant, and of course that as issues emerge, that they are suitably discussed by people within the Institute and addressed. So, first piece of technology. Yes, it works. So what we wanted to do was spend a little bit of time going through the new code, just as a little bit of a reminder, and pointing out some of the areas where we are starting to develop guidance. And then Stuart is going to take us through what that guidance might look like, and also the new requirements for mandatory CPD in relation to, if you like, professionalism and ethics, which will come into effect, presuming that Council passes them, from the 1st of January next year. Now, that doesn't mean, of course, that you need to instantly run out and be doing something on the 1st of January, but rather that from the 1st of January, that work that you do of thinking about, reading about matters to do with professionalism and ethics that are relevant to the code will be something that you'll be asked to advise the Institute about when you put in your annual CPD returns in roughly August, September each year. So first time round, obviously September 2021. So the new code, as I've mentioned, is effective from the 31st of March 2020. I'm quite sure that's deliberate, so it wasn't starting on the 1st of April. So everyone can be quite clear, yes, it does have a commencement date which is real. It is principles-based. A few months ago, I had the good fortune to speak to the professionalism course, and I took the opportunity to take them through the history of codes of conduct. Some of you may be aware that the first code of conduct that the Institute had was actually issued in 1975. Alf Pollard and a number of other great ones wrote that code, and it was around about 6 or 7 pages long, and it had about 67 individual paragraphs in it. We've ended up with codes that have been a lot longer than that, but one of the challenges that as we've entered the 21st century has been, how do we help members address these issues of what is good conduct when we do, in fact, work in so many and varied areas, and when we are continuing to develop new areas of practice, and we would hope that that would continue to happen. So it's very important from the Institute's point of view that we be proactive in ensuring that people are able to think about these things, and I guess to some extent integrate them as much as we can into our regular practice, so that we are thinking about these things. because one of the challenges of I guess, professionalism today, as so many of the recent Royal Commissions, not only into banking but also institutional responses to child sexual abuse, and now the Aged Care Royal Commission when it can recommence, has been to show the fact that people with goodwill and who basically are trying to do the right thing can still screw things up really badly for our clients. And we as a profession want to make sure that that's something that we contribute to as little as possible. And obviously each of us as professionals, not only for the sake of our own career, but also for the sake of one another as our peers and colleagues, that we minimise the risk of that happening. It's not only the fact that we don't want our mum to read about us on the front page of the Sydney Morning Herald. I was greatly blessed in one sense by the fact that my mum passed away about 12 months before the James Hardie matter finally got to that stage. But at the same time, just from the point of view of each of us as individuals, but also as members of a wider body, we want to be, I think, looking at whatever ways we can to protect each other and protect the community that we are trying to serve. So the code itself, what's in it? Well, we know that its scope is now extended, not in some respects, not in any great extent compared to what it was. The code has always, been something which has driven the way in which people, ought to behave, and I guess it's generally been focused around professionalism. But certainly the other aspect of what was in the Constitution in the form of the disciplinary scheme, which is now, of course, a standalone entity, that also works alongside the code and has always taken into account behaviour outside, strictly professional matters. And so, effectively, it was felt that it was important that the code should likewise give people guidance. The disciplinary scheme is an interesting document if you ever have to read it. I do suggest, in fact, that you do from time to time, just to remind yourself about the challenges that are there. I think the process that's in place now from last year is a much more streamlined and straightforward one. Hopefully it is one which none of you ever have to deal with, but no doubt, from time to time some of us will, and so it's important to be aware of that. But the code, of course, is a much broader thing. We're hoping that, that by putting out a code which explains what it is that we expect as a profession that we will each do, will in fact be something which not only drives our behaviour, but also helps to promote the profession to our clients and the general public. And of course the downside is if we don't manage to do that, then we could well end up in the situation that other actuarial organisations have found themselves with less right to self-regulate and less capacity to self-regulate than we are currently blessed with. So, where can you find the new code? Well, recently it has been put onto the same web page as the current Code of Conduct, which is in the bold blue there. And if you click on that, you'll find both the text of the new code and also the explanatory memorandum which was produced at the time that it was finalised and presented to Council. So the background is there, and that's available now for everyone, the general public as well as members, to be able to access. So I would again encourage you to have a look at that as soon as you have the opportunity, if you haven't done already. So there are 6 principles to the code, and some of you will be aware of the background, that when the code working group started on this process, we asked ourselves the question, well, what should we do? Should we just tweak the existing code, which, as you know, has a number of rules and is structured, fairly in terms fairly much of black and white law, and that's one of course, challenges that we've had as a consequence in actually being able to use it and read through it, because it is a relatively lengthy document, and it certainly we found as we were going through and asking people, when was the last time they had looked at the code, and it tended to be, well, either the last time they did the professionalism course, if it was the last couple of years, or maybe, if they hadn't ever done the professionalism course, they might have looked at the edition which was published 2 goes ago. We're hoping that that will not be the case for the new code, and of course, as we'll discuss later, there are ways and means that we're looking to get to be able to address that. So there are 6 principles. I think if you go and pick up principles-based codes for most other professions, you will probably find principles that are very similar. When we started the drafting process, we thought, where's a good place to start? We looked back to our colleagues in the UK, and at that stage they had a 5-principle code. During the time that we were doing our discussions, and there was in fact a member of the committee who was actually active in the UK at the time, as well as being an Australian member. And interestingly, when the Institute revised, the UK Institute and Faculty revised their code and published it in May this year, lo and behold, there was a 6th clause of speaking up, which was also the new clause which we had added. I know that it has been said from time to time that that copying is the most sincere form of flattery or something like that. I'm quite sure that they arrived at their decision independently of ours, in the sense that in the light of things like our Royal Commissions in Australia, as well as obviously things which have happened overseas, that it's an obvious thing that a 21st century code of conduct needs to address. So in terms of what do each of these principles look at? In terms of integrity, there are 3 amplifications in there: respect, confidentiality, and truthful promotion and delivery of services. So basically, under each of the principles themselves, there's something here which tries to focus our attention on particular areas that need to be addressed. And then there are a couple of other matters that we are looking to incorporate into the guidance which is being produced, in addition to those things, around things like voicing opinions, social and other media, and we'll come to why it's here, not somewhere else, communications in personal life, and duties outside the profession, all of which are quite relevant to the way in which we behave and the way in which we demonstrate that we are acting with integrity and honesty in the way that we go about things. So the second one is compliance, and in that area, the matters that are covered are basically keeping up to date. It's fairly obvious, comply with whatever is the law of the land, and also the requirements of the Institute around professional standards, and also, of course, take into account other guidance which is available, which is that's helpful from a point of view of being professional and understanding what the context is of the activities in which you're going. But obviously compliance is certainly around that, obey the law, as I think a number of recent Royal Commissioners have commented. So in the case of competence and care, there are 6 areas which are amplifications. They are providing services, not surprisingly, with competency and care, providing services that are appropriate to the instructions of the client, considering whether you need to engage other professionals or be engaging with other professionals in order to put that advice together, providing services where we have the appropriate levels of knowledge and skill, and so on, that we're complying with CPD, and also where a situation arises that in a statutory role you're replacing an existing member who is already undertaking that role, what steps you should take. So a lot of stuff, again, which is not surprisingly common with the current code. There are a number of matters which are covered by guidance beyond that. Well, how do we address our clients' instructions and also their needs? Because the fact that they may have asked us to do something, is that the question that they ought to have asked? And if we are intending being trusted advisors, then from time to time we may have to assist them to frame the question which actually answers the needs that they have, not just now, but also going forward, thinking about the long-term requirements not only of themselves as a manager, but also the organisations which they look after, and of course the people that those organisations serve. What should we be doing around innovation? If we say that we have to have appropriate skills and knowledge, well, how can we do that if we're moving into a totally new area? And so there is some guidance being drafted around that. And it's also, of course, this isn't being done in a vacuum. The Institute has many other ongoing activities. The Data Analytics Working Group is working on a number of areas around, the use of data and ethics. What is the right way to do these things? And so that sort of guidance as well will be of direct interest clearly to those working directly in the area, but there will be lots of things that come out of that which are highly relevant to people working in other areas beyond pure data analytics. Similarly, the other matters which are raised in the amplifications are covered by that guidance. Now, the fourth principle is objectivity. And here, interestingly, is probably the main difference between the Australian code and the UK code, because the UK code actually uses the term impartiality. And when we were going through the discussions, and you'll recall we had a couple of sessions here from time to time, as well as asking people for input, there was considerable concern around the fact that does the use of the word, if we were to use the word impartiality, does that then prevent people from advocating? Could you then be an actuary who is advising someone on one side or another of a legal case? What sort of situation does that put you in? And we felt, and maybe it's Australian English, I don't know, that the word objectivity, was a better term to use to still get over get through the fact that what we're doing is deliberately done in a way which is not biased to give a particular outcome, but at the same time is able to take into account the particular circumstances of the client that we're advising. And obviously, if we're going to do that, we have to be very careful about the way in which we do it. We still have to be careful to make sure that the assumptions that we use are sensible assumptions. They are not assumptions which are all, for some reason biased up one end of the scale, so all of a sudden we've come up with a result that's a particular way. And of course, even if you are advising someone in that sort of advocacy situation, their legal team have a responsibility to the courts to make sure that they are providing, and servicing the court system and justice appropriately as well. So we need to take that into account. So we felt that was important to be able to do. Again, there are 5 amplifications there. And for some reason, the slides back to front, we've just gone through the impartiality as we were just discussing then. So there are some slight differences, of emphasis, if you like, between our code and that of the UK, and we'll discuss in a little bit what that might mean in terms of who is covered by the code and what that might mean as well. There are obviously areas that need to be covered in that area, such as bias, as I said, advocacy, and also, not surprisingly, reasonably extensive, suggestions around conflicts of interest and how we address and deal with those. So principle 5 is that of speaking up, and speaking up, basically looks at 2 particular areas. What happens if I find my client is doing something which seems inappropriate? What happens if I see that another member is doing something inappropriate? Now, we didn't say there we should be dobbing ourselves in. That wasn't because people shouldn't be doing that, because if you're obeying the code, you shouldn't need to. So therefore, hence the reason for making those 2 distinctions along the way there. And in terms of matters covered by guidance there, we'll be looking at areas such as whistleblowing, what happens in situations where the law might prevent disclosure, for instance. So you want to do something, but there are other things which are going on which you ought to be aware of, and therefore it may not be appropriate to do. Things like anti-money laundering and things like that particularly come to mind. And also, what are some of the practical considerations about how you go about whistleblowing? Obviously, there are some acts which have statutory provisions there which require certain office bearers, certain people holding positions such as appointed actuary to do things in certain circumstances. What if you're not holding one of those positions? What are your responsibilities? And again, we want to develop guidance there, and that's not only going to be the sort of things that people will sit down and write about, but also obviously case studies and things like that, and people simply discussing their war stories, how things happened, what went well, what didn't go well, what we could have done better. And so on the principle of communication, which says members will communicate appropriately, there is simply the one amplification, if you like, which basically looks at how should we communicate in a professional sense. And this is the main reason why those matters of social media and things like that got moved up under integrity, because this particular clause of the Code of Conduct has always dealt with matters of how we communicate our advice to our clients, and it was felt that if we didn't want to muddy that particular matter, and really the use of social media and things like that, we feel has become so integral to the way in which people go about their work that it actually probably does fall under that heading of integrity and honesty as to how you're going to go about using that particular forum going forward. Maybe in 20 years' time it won't be necessary. I'm quite sure there'll be another piece of technology or something else like that out there with which we'll be concerning ourselves. And of course, that's another reason for the code being drafted as it is, as being principles-based, because the world does continue to change. The guidance is something which is just that, and as the world does change, we ought to be as fast as we can, to provide updated guidance, to continue to challenge people in the way in which we think about doing the work that we do and moving forward from there. And so again, sorry about that, what else might be covered or is covered in that area? Judging the amount of communication that's appropriate, and of course demonstrating responsibility for our work. So that, if you like, is just a reminder of what is in the code. Once again, I encourage you to download it, put it on your devices, have it readily accessible, because it's not an extensive document. I think with a little bit of format tweaking, we could actually get the 6 principles quite easily onto 2 pages, or even onto 1 page, which we could stick on our walls. I'm not suggesting that we need to put it in scrolls and attach it to our foreheads or anything like that, as the Book of Deuteronomy might suggest that we should be doing. But at the same time, I would hope that the code itself is something which is sufficient of a heart thing rather than a rule thing, that in fact it will be something which we think about. I'd now like to hand over to Stuart to take us through matters around supporting guidance.
Thank you very much, David. So yes, I'm going to cover 2 main areas this afternoon. The first is around the nature of the supporting guidance that we're intending to provide in the short term, and the first version of that should be coming out shortly, what you can expect to see covered in that, and the approach that we've taken to developing that. The second component I'm going to talk about is the new CPD requirements that David alluded to at the start, and what the expectations are about the type of activities that would meet that requirement. So when we talk about the supporting guidance for the code, importantly, as David has mentioned, the code is principles-based, and therefore it's necessarily high level. It's relatively short, as David said, about 2 pages at the end of the day. And that necessarily means that we need to expound a little bit on the content that is in the short code to convey a bit more meaning and discussion and consideration of the factors that need to go into our consideration of how we act under the code. So while the code itself is fairly brief, we've been developing a first round of guidance, to serve that purpose, which has become a much lengthier, much more expansive document. So how have we gone about that? Well, as David mentioned, a lot of the content of the code was developed with reference to the Institute and Faculty of Actuaries' new code. Conveniently, with the release of their new code, they have prepared a raft of material that is available to support their membership. And so we've sensibly taken some of that and used that as the base platform for our first round of guidance. Of course, however, picking that up and amending it for the changes that were made in the context of the Australian environment for our code, for the Actuaries Institute and what is relevant for that, and the Australian environment. So we've been amending that to try and make it fit something that's appropriate for our institute. So that first draft has been prepared, and we expect that to be released, I think, in November, is the intention. And that will go through a period of exposure where we'll be seeking feedback, of course, as to the content, whether it addresses certain issues, whether there are issues with how we've presented certain things. And we'll be looking for that feedback by early next year so that a revised version of the guidance can be prepared in time for the application of the code from 31st of May next year. So importantly, when we look at the nature of the guidance, when we think about the code and it being a high-level principles-based approach, necessarily much of the guidance must also be necessarily high-level and in some ways principles-based itself, because it's not possible or expected to detail every circumstance or situation that might arise under each of these principles and provide a clear instruction as to how we might react to that particular circumstance. What we do instead is try and provide a range of considerations that need to be taken into account when thinking about those particular issues without being overly prescriptive, because the nature of a principles-based code is that we're accepting that that every circumstance needs to be considered on its merits, and different outcomes might arise in slightly different situations. So necessarily, a lot of the commentary in there may still involve elements that are subjective. Judgment will be required in many circumstances, and we have to expect that in certain circumstances a range of opinions will still exist as to how to interpret the code in certain circumstances. Importantly, in the document that we've produced so far, we haven't made use of extensive case studies or examples to work through to provide examples of how we think the code should be interpreted. There's a couple of reasons for that. Case studies are fantastic if they encourage discussion about how elements of the code might be interpreted. But it's hard to use case studies in the short format that would be required in the supporting guidance to actually provide instruction or deliberate interpretation, unless they are so blindingly obvious that they are not actually informative at all because they're obvious in the first instance. I use a lot of case studies in some of the professionalism course and other ethics discussions that I've participated in. And one thing I've learned is that no matter how well you construct a case study that you present to a bunch of people, people will be able to come up with circumstances or interpretations of the factors around that case study to say, well, in this circumstance, if it was in this product range, in this legislative environment, you would have to do this. And someone else would say, well, if I interpret it in this circumstance, I would take an opposite approach. So at this stage, we haven't used case studies in that example. I do believe, however, the case studies will be important, as David has alluded to, as part of our ongoing discussion about the interpretation of the Code of Conduct, because case studies are incredibly useful as a way of illuminating the way different people might interpret that and forming constructive discussion about how to interpret the Code of Conduct. The code also makes reference to, the code guidance also makes reference to other documents and other reference points where necessary. David's mentioned the disciplinary scheme, and there are some areas such as whistleblowing, which are relevant to the speaking up principle, where the content and the depth of understanding that's required to understand different whistleblowing obligations in different circumstances is far beyond the scope of what we can include in the guidance document associated with the code. So instead, there is, for example, in that particular case, an e-learning course on the Actuaries Institute website, which is far, far more comprehensive than we would ever be able to include in the guidance. And so we would refer people to that content instead, rather than trying to expound on that in the document. So that all said, we've ended up with a document that is in the order of about 50 pages long, so it's reasonably lengthy. We look forward to everyone having a read through and providing their commentary, which can include a commentary about whether it's too long or not long enough. So we look forward to receiving that feedback over the next couple of months after its release, so that we can get ready for the implementation of the new code on 31st of March next year. So the last area I want to talk about is the new CPD requirements that are coming in. Hopefully most of you have seen the note that came out from the Actuaries Institute on, I think, 3rd of October. Basically, and in summary, including a requirement that as part of our 100 points of CPD that we're obliged to maintain every year, from 1st of January next year, 5 points of that must be grounded in areas of professionalism or ethics or areas related to the Code of Conduct. So I want to talk a little bit about why this change has come about as a companion piece, if you like, to the release of the new code. There's a few factors that were considered in reaching this recommendation. So if you look at what's happened up until now, the main point at which any of us formally go through any discussion or involvement in a discussion around professionalism, ethics and our code of conduct happens at one point in our career. And that's been when we do the professionalism course. Typically done either just before becoming a fellow or an associate or at some stage during the qualification process. That's obviously a really important time to be thinking about professionalism when we're going through that process and taking on that mantle. But I think we would all agree that it is by no means the only time we should be thinking about those obligations. That's become no more apparent than it could possibly be than in the last couple of years with the experience with the Financial Services Royal Commission, which has reminded everyone, I think, not just in our profession, but everyone in business, whether in financial services or elsewhere, that we constantly need to be reminding ourselves of our obligations and the expectations of the community and how to do the right thing, ultimately. So it's a timely reminder that we need to be doing more to be talking about this on a regular basis. And in considering that, we also looked externally to other actuarial institutes, and it is notable that others like the IFOA and the American Academy of Actuaries have also introduced minimum CPD requirements relating to professionalism and ethics. So this is not just Australia making this change, it's being factored in globally as well. And importantly, we need to make sure that we don't become complacent about these issues. That's how these issues have arisen in the industry, is in some cases because of complacency and comfort with the way things are. We need to be constantly challenging ourselves in this area. So, the new requirements that came out of that discussion, which are alluded to in the note that came out from the Institute on the 3rd of October, is that 5 points out of our annual 100 points minimum CPD are expected to be related to professionalism. I think the term that will be used is professionalism training. And there'll be some additional wording about what that means. But the intention is to cover aspects of professionalism, what it means to be a profession, what are our obligations as a profession, ethics, considering ethical dilemmas and how we go about good ethical decision making, and understanding of areas that are relevant to the Code of Conduct. So that might include, for example, issues around conflict of interest or whistleblowing or some of those other factors that we need to consider when we act under the Code. So the intention is that the requirements are integrated as cleanly as possible into the rest of the requirements of Professional Standard 1 under the Code. And by that I mean we're talking about the same points with the same weightings that are used for the rest of our obligations. Like the rest of our CPD, it is self-assessed. So in contrast to, for example, the IFOA and the American Academy of Actuaries, where they have specific requirements for face-to-face training in these areas and components that must be, where that time must be achieved through specific activities delivered by the Institute and Faculty of Actuaries. For us, we're adopting the same approach we have adopted for the rest of our CPD, which is that it is your job to assess whether the activities that you're undertaking meet that requirement of the 5 points that need to be related to professionalism training. And of course, the training can be met in many different forms, whether that's reading or attending relevant presentations or sessions, or developing material for conferences or any other aspect that might be related to professionalism. So the intention is not that there's any onerous change here, it's just that in addition to counting up our 100 points, we need to make sure that at least 5 points worth of that meets this requirement every year. So, what can be included? Well, the intention is that there's a wide variety of things that would be included or could cover these 5 points. Obviously, this session would be one of the activities that could be used to meet that part of that 5 points. Some of you might be disappointed to note that this is happening before 1st of January next year, but the good news is that we'll be having another session in March next year to deal with the feedback that we received from the exposure period. So that session in March next year will be part of what can count for the 5 points. Simply reviewing the code and the related guidance material will count as part of that 5 business points. And in a related goal, one of the things that the Guidance Committee is developing is for the professionalism course, there's actually a Code of Conduct online quiz for the old Code of Conduct. We are picking that up and amending that, and we will make that available to the whole membership as part of this process. So there will be an option on the Actuaries Institute website to undertake a relatively short multiple choice quiz about the Code of Conduct. You might think, well, that seems fairly trivial as an activity that would meet this requirement, but 2 things are important about that. One is that the questions are designed to actually force you to read the thing. They won't be really obvious. They will require a rereading of the code so that you actually look at that. And interestingly, when you look at research around ethical behaviour, there are studies, for example, that where university students were given a test and they were given an opportunity in that test to cheat. And so they looked at scenarios where there was no opportunity to cheat and what the results were, where there was an opportunity to cheat and what the results were. Unsurprisingly, the results were significantly higher. And then they looked at a situation where at the top of the piece of paper where they had to answer their questions, there was a statement saying, you are reminded that this exam is being conducted under the honour system of whatever university you are attending. And all of a sudden, the results were back at the same level where there was no opportunity to cheat. So the research says that simply being reminded and having these obligations top of mind on a regular basis actually changes our behaviour. And that's one of the reasons why we want this ongoing requirement, so that this obligation is top of mind. So even that seemingly trivial activity of a 10-question multiple choice thing is something that will hopefully contribute to that. There are obviously lots of other activities and sessions that would be relevant. This year's CPD tour, which was about professionalism in the new world following the Financial Services Royal Commission, would be directly relevant to this. A couple of years ago we had a CPD tour presented by Dr. Simon Longstaff from the Ethics Centre. That would be relevant. And there's no end of sessions in the Actuaries Summit or Financial Services Forum or other sessions where some of those presentations relate to professionalism and would meet this requirement. I mentioned the e-learning whistleblowing course earlier, which would also be relevant. And there I'm just talking about the options that are available through the Actuaries Institute. There are, of course, a wealth of other activities that are interesting and relevant in relation to ethics and ethical decision making that would be well worth considering. And for anyone who's interested, I happen to be running a session in 2 weeks about professionalism and ethics in this very room, if that, although again that's a little bit early for next year, that would be directly relevant. So lots of options out there, and importantly the CPD Knowledge Hub, I notice we've got a plug for that here. It is a vast resource of CPD material, and one of the tags that is available to search on in that is professionalism. One of the tasks that we have as a committee is to go through what's in that the CPD Knowledge Hub and just confirm that all of the things that are tagged as being about professionalism are relevant, so that we can say that if you're doing some of the things or reading some of the material tagged as being related to professionalism in that resource, then that is material that you can use to meet the 5 points of minimum CPD requirements. So that's a summary of where we're heading with those CPD requirements when they formally begin to apply in a couple of years, from 1st of January next year. And from there, I think we're moving to any feedback or discussion or questions that anyone might have. James.
Thanks, Stuart. And for those who are in the room here, if you want, there are microphones coming around, and we're happy to have either questions, comments, and as I said, anything which relates to what you'd like to see in the guidance would be helpful. Because the session is being recorded, we will be able to go back and get that input and share it with the other members of the committee and going forward. So, please.
James Purvis, just a question on the last piece, the CPD. Conceivably, reading the Royal Commission final report and making detailed notes could count as professionalism type CPD, because there'd be a number of aspects of that. I mean, it would take a hell of a long... I mean, I've read a fair bit of it, but... You know, and it's enjoyable reading because it has some interesting...
Well, there's plenty of it.
It is. It's got some really interesting insights in it. But would that sort of thing possibly count?
Look, from my point of view, I think absolutely. There are a number of reports that we've seen come out recently. At the Actuaries Summit, I did a presentation that drew on the Financial Services Royal Commission report, the APRA Prudential Review into CBA, and in fact the Ethics Centre review into Cricket Australia, which goes to ethics and behaviour in organisations. And I think any of those documents are relevant to our consideration of ethical decision making and our obligations as a profession.
I had one other question relating to the earlier part of the presentation. What is the status of the code guidance? So to take a hypothetical example, a financial institution finds that it's not served its customers properly. I mean, this sort of thing can actually happen, as you can imagine. And class action takes place, and one of our members ends up in the witness box, and they are cross-examined by the QC saying, well, your behaviour did not meet your code of conduct. Could that question be broadened to say, and not only did you have to adhere to the code of conduct, but you should have known and adhered to all the other stuff that's in the code guidance? And then in the discussion, you made reference to the fact that the code guidance cross-refers to the disciplinary scheme and also to some educational material on the website. So could a clever QC try and draw all of that in and say, you, Mr. Actuary, should have known all this stuff, and your behaviour should have reflected a solid understanding of all this stuff, not just the code of conduct, but the guidance, the disciplinary scheme, and anything else that... So with that in mind, with that question in mind, the authors of the code guidance, have they taken into account the potential uses that people outside the Institute might make of this in legal circumstances?
One of the advantages that we have is we have a General Counsel professionalism, Linda Vogel, and Linda will in fact be going through the material and making sure that it is, if you like, fit for purpose, thinking through exactly those issues. Because at the end of the day, the fact that guidance and documents exist, yes, a clever QC will go and dig those out anyway. I guess what we're trying to do is to make sure that all members have as much access and ease of access to those things, so they do have the opportunity to think about them before they get there. Because at the end of the day, yes, if you end up in the witness box and the clever QC is there, he will have done his research, he'll have trawled through the internet and everything else and pulled together all these things. So we want to be, on the one hand, we do want to be very careful that we're not creating a rod for members' backs in what we write, but at the same time, we also want to make sure that if there is information out there which can help people to do their job better, think through these things beforehand, that's really what we're trying to do. But yes, James, it's certainly a potential issue.
And I can't remember the exact wording, but I think at the introduction of the guidance, one of the statements in there is that the guidance does not replace the code. The code still is the code, and so...
Yeah, from the point of view... Yeah.
But it could be regarded as being additional to and part of the code.
Yeah, yes, yeah.
Yeah, so I had a similar point to Duncan Rawlinson. I have a problem with the word guidance because it has a connotation of guidance note to it. And I'll declare my view now, which is it shouldn't be of that standing. I think what you've just described is a problem because it just becomes supplementary to the code. It should be crystal clear at the start of whatever we're going to call it, exactly what its status is. Now, I have a view, the profession will have its view, but it should be crystal clear. That's ambiguous, what you just described. I favour something more like information note. We're not suggesting it be titled that, but
Yep.
the introduction on information notes is much clearer about its standing in my mind. It's clearly is of education value, that's great, but it shouldn't be a rod. And there was an intended change to the disciplinary scheme that was once the new code came in, and I haven't gone back to check whether the scheme's been changed yet, which was to narrow the requirement such that it was the Institute's expectations as expressed in the code, full stop. Not anything else ambiguous beyond that, and I think we need to be very careful how we position this other document. And then the last observation is if it really is the Institute's view that it should have force or standing or whatever you want to call it, then I'll declare now, without even having read it, 50 pages is ridiculously too long. It would have to be much shorter so that people actually have an ability to really understand what is expected of them. I mean, something much more concise than a 50-page read.
Yeah, Duncan, I think that's quite fair. The intention is not that this document is, if you like, the rest of the code. It is guidance. It is there to help people think through issues, and definitely not to be something which can be extended. Now, again, back to James's point, yes, the clever QC will say, well, all this other stuff existed, but it comes down to what its status is. The disciplinary scheme does require that we obey the law of the land and the code and the professional standards of the Institute. The code itself is quite clear in saying that professional guidance, of which this would be is something which you ought to be aware of, but is not something which is going to be used to hoist you on a petard. Similarly, I would imagine the disciplinary scheme, because it's framed that way, will operate in exactly the same way. Breach the code or breach the professional standards, and you're in trouble. The professional guidance material, which is other stuff that the Institute produces, like information notes or guidance notes or whatever they happen to be called, don't fall into that same status and do not expose you to that. There will obviously be times when you're in a situation where you might well find that someone cross-examines you, why didn't you use that? In which case, like any good actuary, you will have thought through, well, it wasn't relevant to this particular situation for these reasons. We have had a question that's come in from one of the webinar listeners. I'm curious why Principle 3.6 applies to statutory roles but not for other roles. That is an interesting point. The main reason it is there, of course, is because that was in the previous code. There has always been a section in there which is, there's been an expectation that members will consult with their predecessors, and likewise that someone who is being replaced in a statutory role will make themselves available to talk to someone else. Clearly that would be, I think in most circumstances, wise business practice on the part of an incoming person taking on a new role. In any case, if the predecessor is available to be spoken to, but certainly the reason it's not in the code is because that's not an expectation that you will do that, and that it would be something that would be a normal part of a changeover. So obviously, good thing to do, good thing to think about doing, but I think that's why that carve out is there to talk only about statutory roles. Further questions or comments?
In terms of sorry, Duncan, again, in terms of contents for the guidance, one of the things that worries me a bit as I age through the profession is that that some of the lessons of the past just get, well, at worst forgotten and at best just kind of lost in the mists of time. So I'm not sure whether it's in there, but I'll call it education piece rather than guidance. Whatever this document is, I think it would be not so much case studies. I think it would be helpful to have some kind of précis of some of the big things in the past. Hardy's is already mentioned, HIH, Equitable maybe, if we kind of cross borders. These were momentous things in the mid to late 90s through early 2000s. There were other instances in the local market here, early, mid-2000s, which might be useful reminders for people. So kind of younger members of the profession coming through, there are some very hard lessons that were learned by individuals and by the profession as a whole, which prompted a whole raft of, I don't want to say navel-gazing, that's the wrong term, but a whole raft of thought within the profession as to where we need to position ourselves as members. And I worry that we risk forgetting those lessons. So if there's a place to capture those, and it's not case studies, it's, as I said, it's a précis of, what was done, why was it an issue, or what should have been done that wasn't done. Something like that has kind of real life stories to it, I think would be helpful.
Examples of past failures, essentially. Essentially. And I think that's an interesting question, because at the moment in the professionalism course, I think there is a segment that deals with exactly that, giving a real life story about something going terribly wrong and the professional challenges and code of conduct challenges that arose in that situation. But of course the professionalism course in its current form ends at the end of this year. So there is a new course replacing it, but whether that encapsulates that type of story to make sure that it's still part of our learning process collectively, that's a good question.
And then lastly, perhaps more jovially, one item for guidance, because I have read the revised code and it's not dealt with in there. I remember one of the sessions we had on the new code in this room, I think last year. I won't name them, but two very senior members of the profession were diametrically opposed in their views as to whether, as an actuary serving as a board member, whether they were obligated to whether the kind of some of the things that were in the code applied to them. One of them said stridently yes, and the other said stridently no. So I think it would be helpful to clarify that point for the sort of those of the members of the profession that do find themselves in board roles.
Yeah, thanks for that, Duncan. I think it's fair to say that that's actually been one of the great challenges for people moving into into board positions over the years. I am aware of at least one very senior former actuary who has resigned from the Institute because he felt he could not be in step with the code and also doing the things that he felt he needed to be doing on the board. And it may well be that there are seasons in our lives like that. Now, I think most of those of us who are directors have managed to balance that. But certainly there is an issue around, if I'm sitting on the board and I am an actuary, does the board think I'm there in an actuarial capacity? And I think you do need to be very, very clear about, to your colleagues about how that goes. In one sense, as a board member, you are there, you're there as equals, and you don't actually operate independently except as a board. And the other members of the board technically cannot rely on one expert on the board and say, well, he told us it was okay, and so therefore we took their advice. Technically, the board should go out and get independent advice from someone who's not on the board to that extent. But at the same time, in trying to interpret the information we get, it is clearly valuable to have a lawyer, an actuary, an accountant on the board to help the board members think through those things and understand the technical professional advice we've been given. So yeah, that's clearly something which we are looking at. I've received a response to one of Duncan's earlier comments, and I presume this has come from a member of our committee, our guidance group, because right up front, the guidance note currently says that this guidance is non-mandatory. It imposes no obligation upon members over and above those embodied in the code or professional standards. Having said that, Linda is also going to go through and make sure that that wording in itself is sufficient for our purposes. Thank you. could the removal of impartiality, sorry, this is another web question, could the removal of impartiality have a negative impact on the role of AA if we are now seen as advocates? I think it's fair to say that that's not the purpose at all. If you read through the section on objectivity and compare it to the wording of the UK impartiality, you will find there is massive agreement between the two. There are very few differences there. But as I say, we felt that it was important, given Australian language and that sort of thing, that we actually made that differentiation. Clearly, you know, those who are undertaking statutory roles, there are particular requirements which are set out in professional standards which prevent you from being an advocate. So even if the company wants you to do X, Y, Z, it is not within your remit to do that. You have a responsibility, to the company as a whole, not simply the management team, as well as to APRA and to the profession, to be in those circumstances impartial as well as objective. Further thoughts or comments before we wrap up? There's a comment coming to me now. Great, thank you. Will there be a session at the Actuaries Summit next June on the new Code of Conduct? An excellent question. I hallucinate that the organisers of that event may well consider doing so. Certainly one of the reasons why we've got the Insights session already planned for next March is because we recognise the fact that this is something that needs to be ongoing, and the very reason why we will continue to develop new material and to develop new ways of delivering this is because it's actually engaging with the issues and you thinking about it and asking questions and us being part of discussion, which is going to move people forward and help that when we actually get to those crunch times when the management team ask us to do something, we've already got top of mind how we might respond to that, having thought about the issues that have come through. Duncan's earlier question about do we have anything on the Institute website and that sort of thing about, well, what have been some of the challenges that have happened in the past? Obviously, in the Knowledge Hub itself, there are probably some presentations that have been done from time to time. Obviously, things on the recent Financial Services Royal Commission. Unfortunately, if you go and have a look at the disciplinary scheme page, you will find there is a link there to all those who have previously been disciplined. So if you click on that particular link, you'll find David Minty's name is there and the details of what was found against him and the reasons why that was and the fact that I was reprimanded for that. Similarly, for the other people who have been through disciplinary processes where that has resulted in something public like that. Now, that's fine and good. That's about a dozen cases or something like that, which you can read about there, and they're obvious examples that you should pay attention to. But in addition to that, clearly other learnings that we've had, part of which, documents like the Royal Commission reports and things like that do in fact document very well. And if we can find ways of conveniently condensing some of that stuff, we'll certainly do that. And hopefully that's happening as a normal part of the process as we run these sessions. So look, I'd just like to take the opportunity to thank everyone who's here today and who's on the webinar. We trust this has been a useful session, again, of attention raising and things like that. There will be an email that will go out sometime next month from the Institute giving you the link to the draft guidance material. As I say, that draft guidance material will, like the code was, the new code was until very recently, be behind the member firewall, so you'll be able to get to it if you're logged onto the Institute website. But come March next year, once it's been through the process of review and we've had feedback from the members and any further feedback that might come through, then it will be basically public along the same lines that the code will be from that date. So thank you all very much for being here and enjoy your reading of the code.